Good morning. Lorena, I'm sorry. One more point. When you ask questions, please interrupt us, but make sure you put your hands up and wait for the microphone because we are recording and so we won't be able to hear the audio of the question, so that can be in the audio as well. Thank you very much. Thank you. My name is Lorena Garnica. I'm Senior Manager for law. It's an area that's under tax within EY, and recently we have really strengthened public law, especially in public procurement. So the people who will be helping us today with their talk for legal, specific technical knowledge for public procurement are truly experts in the field. We have Carlos Ortega, who is a specialist in special procurement regimes, so not those that are governed by the general regime for public procurement. He is specialized in public procurement and public management. He has worked in the public sector, and his most recent role was General Secretariat of Aguas de Bogotá, or Water Works in Bogotá, and he is specialized in public services too. Gilberto Estupiñán is also a lawyer in the area. He is from the Universidad de los Andes. He specialized in administrative management, and he is a candidate for the master's program for public procurement and administrative management, also at Universidad de los Andes. He's traveled and lived in London for business, and he's one of the few lawyers in Colombia that has been part of law firms that have channeled all these successful public-private partnerships that have been finished successfully with contracts that have been have happened successfully as well. So public hearings or in situ disputes with counterparts for contracts. So they're lawyers that truly have special abilities. And I'm the honor of leading this area. I'm the senior manager, and also, in fact, I have a more private law academic life. I did a master's in business law outside the country, and when I arrived, for different reasons, I had to sit on the other side of the table in the public sector. So I was general secretary of an entity that had 10,000 workers and assisted people with their needs in the whole national territory, and I was able to see the other side of public procurement. So in the end, that's the path I went down for my professional career. So without further ado, we hope that this couple of modules that we're going to present today and tomorrow will be completely satisfactory for you. And if at any point in time you have a need that needs to be satisfied, such as a question, a doubt, a query, we will immediately try to cover that. I'll leave you with Carlos now. He's going to talk about the main components of the public procurement module from a winning point of view. Thank you very much, Lorena. A very good morning to you all. The objective of this module is to be able to position you within or to be able to give you a little bit about the normative framework for public procurement processes here in Colombia. For this module, we have established the following points in order to explain the normative framework, the legal regime that is applicable to contracting processes, so that you can feel completely assured with regards to how these processes of procurement take place, and to look at proponents and in which different situations you can take part in these processes. The first point, we're going to look at the differences and benefits of legal regimes within legal frameworks that apply in Colombia. So a general regime that is applied to processes in most parts, and in exceptional cases although they are underwritten with the state, the standards that apply to these are different in these exceptional cases. So we're talking about two company legal figures that are known as consortiums or temporary unions, and they have certain particularities that could benefit you as eventual proponents or participants in public procurement processes. Then we're going to revise what these exceptional clauses, guarantees and sanctions are in state contracts, different types of particular contracts that will be celebrated, private contracts that you will find within the standards that apply to these cases, how they are underwritten, how they are perfected, liquidation of state contracts. A very important aspect in Colombia, and that is the electoral guarantee laws. And next year we will be in Colombia in an electoral process to choose the president. So generally speaking, we will see how you as eventual companies or foreign companies can participate in processes in Colombia, what kind of normative issues apply, and what requirements apply there as well, or conditions. So Colombia is different to the UK because the legal regime has Germanic and Roman backgrounds, so we do not apply common laws as the case in the UK. This means that our rules are not provided by precedent or past similar cases. Rather, we go into detail with regards to the actual standard, the rigor of the words themselves. The level of detail is quite wide, so it's really important for you to understand the three important points that are applied in normative issues when it comes to public procurement processes in the country.
The political constitution as a framework of all the activities that are held inside a country in terms of public procurement has these 5 articles where you can find the origin of the different contractual elements that are executed inside a country. Afterwards, in considering the political constitution in terms of hiring, we have Law 80 of the public contracting, that is the general rule that is applied to all the contracting processes where an entity of the government is a contracting part. It is the one that is awarding the contract. Then we have an exceptional element where we don't apply these norms for specific conditions that we are going to see later on. And finally, there is a specific law that is 1508 of 2012 that specifically regulates all the issues related with public and private alliances. That is something that is going to be applied in module number 6 that we are going to see tomorrow. General Institute of this work is divided into these different issues and is a way to locate yourselves inside the norm. When you're going to see the norm, in order for you to understand and to see according to what you see, where do we have to look now? The first part is the general dispositions, the starting point, and this is going to give you some general elements in considering this norm about how to understand different points that are being tackled, different issues, and which are the applicable regulations that you can find. Later on, we are going to talking about a second part that is very important because it applies for all the contracting terms, both for exceptional and others. That is the principles of public contracting. The principles of public contracting are absolutely necessary to be taken into account in all the regimes, and they are normative parameters that always applied and that always have to be observed. After understanding which are the public contracting guidelines, this will explain you which is the state contract. It's going to give you definition, which are the different parts, which are the procedures in general terms, the selection processes, so that later on it can explain which are the different responsibilities of the entity or the one that is going toward the contract. When we talk about a public contract, a state contract, we are talking about delegation of a function on a third party. So the state contract has the purpose to receive the support of a third party that has an expertise, has a specific knowledge that maybe the state doesn't have, and that needs it to be able to cater to those needs. So, considering this condition of the hiring entity, they have some specific responsibilities, and they are found in the chapter number 4 of Law 80. Finally, we find a final point that talks about which are different controls. We have some entities of the government that is holding some controls in disciplinary areas, and they are specifically regulated for state elements. And we also have some citizen controls. We have some the follow-ups that are properly regulated in this chapter number 5 of Law 80 and all the regime of hiring. In the end, we have the final chapter that we talk about resolution of different conflicts that can appear from the contract execution. In any relation, we can have some differences, we have some issues on the performing, and the law itself states which are the different mechanisms that have to be taken into account that are properly authorized for the resolution of these possible issues that can happen during the execution of the contract. With the general regime that we have already mentioned, we have a special regime as well. The special regime is that regime where even though the entity that is hiring or that is awarding the activity is an entity that, even though it has a 100% participation of the government, or is mostly owned by the state, it will apply these norms. In that case, the Law 80 has defined that due to the proper conditions where we have the market or the person that is effectively holding the business, it is more proper for terms of competitivity and for terms of benefit to apply not only the special norms for Law 80 of the contracting document, but some special norms as well, because the contracting element find some activities, some different actions that you can specifically see that can effectively affect the competitivity and the efficiency on the delivery, on the rendering of service. So what the state is always looking for is to satisfy needs, to fulfill services and to write to the citizens with the different purposes that they have. So if I have a particular with those terms in those conditions, to compete with particulars that don't have them and that have a much more flexible regime, it's going to be very tough for the state or for the particular that is going to satisfy those needs to be in conditions to provide to render those conditions in a proper manner, even though this list is not a taxative list. Additional, on top of these regimes, we have some other regimes that are exceptional and that we are going to see as characteristics or conditions later on. First, we have Ecopetrol and the sector of hydrocarbon. Ecopetrol is a company for Colombian oil drilling services. So, as it is a very sensitive market since 1993, when we have the first law of public contracting that is in this moment valid, they considered that Ecopetrol had to have some special contracting procedures. So their work is not held for the same regime of public contracting, but on our own regime. Also, there is a monopolistic condition of the state that has some specific reasons for economic purposes, of course. So, for the sake of convenience, the work that they have is different from the rest of the sectors. So, on the rendering of services on home or not home is a competitive market. It's a market where the most of the people that are participating on service rendering or others are particular. So, if the state wants effectively that the participation, the hiring in these services is something balanced and is properly made in the proper fair conditions of competence, they should have equalitarian conditions. That's why when we're talking about utilities and domiciliary services, the standard is different from the public hiring. The educational services are public universities. They are also services that are exempted from the public hirings regime and everything that has to deal with the trust, where a company from the government is providing resources for the management, not for the use, but it's different, so that from these administration can be part of the equity of the company. It is taking the same elements of the exceptional hiring. So, as we were saying before, we have the two regimes, the general regime and the specific regime, which are bound by the principles. Even though the principles are for the Law 80, they are going to be bound to all the contracting elements. And for you as possible offers, you have to take this into account, because quite often the markets where you want to participate in the country could have some exceptional regimes because they are situations of different competences. You have to take into account that the principles are going to be applied to your contracting principles. Well, when we talk about general regime, the most important thing, as I told you, we have the General Statute of Public Procurement, all the work they have within, and from these law 80 we're going to have some specific types of tender that are properly stated in the law, and we're going to see the selection mechanism for this contract. In the prior module we found that there were some procedures to know the proper contractors in the country. So these selection procedures that were properly explained are processes that are nominated in the norm. It is going to tell you under which conditions we're going to have some specific processes. There is a budgetary element that is important, that is the resource with which we're going to guarantee the rendering of the duties of the contract. That is something that comes from the government, and as it is a public element, it has some specific characteristics and a specific protection as it's a public equity. And the exceptional clauses that is going to catch your attention a lot, because we're talking about particular conditions that later on we're going to explain more in detail. But for you to understand, we are talking about clauses, some specific particular conditions that in the contract that are bound by the law 80 are applied regardless of the nature of the selection or the contract that is being awarded. The types of contracts and the types of selections in general side are public tendering, abbreviated one, direct selection, and others. So these are going to be explained in detail. And when we're talking about exceptional clauses, we're talking about these 5 final points. First, unilateral interpretation, modification, or termination by the state in one reversion that has a very specific element, and we're going to see later on. And the termination, the expiration of the contract. That's something that was set for the contract that are bound to the law 80. Also, we find the specific regimes. As we said before, the framework, the selection framework and hiring framework is not the one from the law 80, but is the statute or the norm that specifically the entity that is hiring this service defined for these processes. That means that it gave a complete autonomy for the different entities that don't have to affect the law 80, and they award their own awardings from different specific contracts or elements. Now, the budgetary issues are different because as they are exempt from the hiring regime, in terms of budget, even though they're going to have a participation from the government in their budget, they're going to have some particular budget, some money that has been given by a particular party or a third party. So we're talking about a mixed resource. For that purpose, the regime can be exempted because as it is not 100% public, the conditions, the guarantees that have to be delivered for the execution of the resources are much more flexible, as they are not subject to the control of the public resource. And in this case, we don't have the exceptional clauses that are the ones that we were mentioning before. So these clauses are derived taken by the law itself. So when we talk about law 80, these clauses don't apply here. We have some hiring clauses that are specifically set by the regime, and Gilberto is going to talk with us now about this. Good morning. Good morning, thank you. It is a pleasure for me to be here. I guess Lorena already introduced us. And now, after having identified the general regime and the specific regime, I guess that we can tell us now who can hire with the government in in Colombia. First, the subject of public contracting is the natural person. That means you, me, or any person that can, in an individual manner, to hire with the government a set contract for whatever the government wants. So, for me to be able to hire with the government, how can I certify that I'm a natural person? With my ID card or my foreign ID, etc. Not talking about natural person. Talking about legal persons. For legal persons, we have people that can effectively have a contract with the government, and to show the capability that they have to hire, they have to show certain certificates of legal existence or from the country that they come. So what is this contained inside the certificate? How much the person is going to exist here, and some financial terms that are included, and legal representative that also, when we are hiring as a company, something that we have to develop later on, we have to take into account as well. And the reason for which we have developed this is the consortiums and the temporary unions. These gives you and the nationals to associate two or more people with the purpose of requiring gathering the result, the requisites of the people to execute the contract and execute in the best way possible. So through the consortium, we can associate to talk about our leverage or economic expertise, because, for example, your experience is one, mine is another, and we together we can set this contract into motion. That's why the government has given the possibility to particular people, because we can talk about natural person or legal person, to associate together in a way that they can execute a contract. However, when we talk about consortiums and temporary unions, they appear like if they were the same. If you read the two definitions that we have set of them, these are definitions from the norm, and it's difficult to see the difference between consortiums and temporary unions. Now, the difference between consortiums and temporary unions is the responsibility that arises from them and from the people that participate in them. So first, the consortium. The consortium is the responsibility of the people that create it for the fulfillment of the contract, and that means that they are solitary. That means that all the people that are part of the consortium are responsible for the complete fulfillment of the contract, and the contract can require to one of them or to all of them the fulfillment of the duty. That is the solidarity responsibility. And in terms of consortium, we have this type of responsibility. Now, it also works for the temporary union. That means that we can request to anyone that is asking the contract fulfillment. But we have set some elements when this is not set as it was agreed. For example, it takes longer to complete the contract, and that creates certain penalties. So the penalties that I can have for the contract breach are set for the member that was in charge of executing that specific work. For example, we can do an example. We are going to create a building. We're going to set up all the structure, and I'm going to work with the windows. So if you create building in the proper time, and when I have delays in the windows, so the sanction, the penalty only is for me, but is only demandable or requirable for me. But the fulfillment of the contract is both for you and for me as well. Here we try to show you the different elements where we have both consortiums and the temporary unions. First of all, they are created by a plural number of people, and whose goal is to create a business, and they have a same purpose. They have no legal personality, which in your case is less prestigious, because in order to create a consortium or temporary unions, you have to go to the Chamber of Commerce, but not only to deliver the documents they are asking, but those elements, the elements that are binding these people is the consortium or temporary union contract. And I want to stress here, because a lot of people take a consortium format or a temporary union and says, well, this one works for me or this one works for me, I'm going to set this. This is something that is set on revision by the entity, and as I told you before, we have the responsibility both individual and collective. So it's important, and we have already provided several counseling to several contractors of the government, that you have to revise to check the document that is binding you to another, because there is a topic of important responsibility that requires your attention. The third similarity is that, for example, they can have a shared pool of resources, and something else in tax terms, they are treated the same. So we need there are some other things that we can tackle later on, but basically this is what we have as similarities. So we try to do this in a more didactic manner to talk about the differences, and you're going to find it, and it's very important, because there are people that are still contracting with the government thinking that the temporary union and the consortium are pretty much the same. Some people are hiring with the government and said, I don't care, temporary union or a consortium, and some people believe that temporary union says that they are only responsible of fulfilling their duty. So if I was in charge of Windows, not about the rest. And no, you have to be liable for the entirety of the contract. The only thing that you're not responsible of is there is a penalty of one of the persons that is working with you for the breaching of the contract. That person is in charge of paying that contract only. But it is something very important, because we have found some companies that have been hiring with the government for many years, and they are still confusing the different figures. So this is something that allows you to be part of the contracting environment in Colombia. It's important for you to take into account that difference that I was mentioning. So I think that so far we're talking about consortiums. If there is a question, please do it. And now we're going to continue with exceptional clauses that Carlos mentioned before. This is something important, something specific from the Colombian government, because as it says, this is exceptional from Colombia. And the reason for which we have developed these exceptional clauses in the legal ordaining of the country is protecting the execution of the contract. So what we want to do with these exceptional clauses is that the contractor should effectively finish the contract. So these tools with which the government has for the contractor to execute this in the proper manner, in the way that it was properly set. So something important that should be taken into account is that, despite the fact that even though you don't find exceptional clauses in your contract that we are going to mention, they are already set. So maybe you can read the contract and you don't find exceptional clauses. But as the law is pointing out, that they are not set in the contract, they are understood as properly set, they have to be included. So it's not only checking the contract if it's not there or not, but understanding that it's properly set. So we're going to be reviewing them one-on-one. The first one is the unilateral interpretation. There are some cases where in the contract execution between the particular and the government, there is a problem of interpretation. You understand these from the scope of the contract, and I understand these. And the time goes on and on and on, and the idea is that we want to continue with the execution of the contract. So the entity says, what I'm going to say is that I'm going to give an interpretation, an unilateral interpretation. So I'm going to give the definition to this. You're not going to be interpreting the contract, because we couldn't agree, and that is not a competence of the state. It's not that I'm saying I'm doing this because I want to. No, it's like it's coming out of thin air. Is that the government has to issue a document that is called administrative act. Well, they state the reasons for which they have to be objective reasons for which it is doing this on unilateral interpretation. So it is not something to say that so it happens every single day, and the state, for its own sake, for its own benefit, they are interpreting this. And you have to consider this, and it's something that has to be considered as well. Also, unilateral modification. We have even found scenarios of this unilateral modification where the one that is benefited is the government. Sometimes also the particular is benefited by the unilateral modification. So what is this exceptional clause? This means that the state on its own volition or its own reason finds enough grounds to change the contract in order to safekeep its proper execution. So, I don't know, for example, I'm going to modify the contract in terms of lapse of time, because this allows me to have a better performance of the contract and I don't have to rehire again. So again, this has some limitations, as I was saying before. This has to be done through a motivated administrative act that points out the reasons for the change of the contract and has some limiting. It's not that the contractor has to assume at once the modification, but if this modification creates a change in the value higher than 20%, the contractor can say, I won't do that. So they resign the modification, and now the entity is the one that has to solve the problem on its own. Third, we have the unilateral termination, and I think that is the one that is the most regulated of them all. We are talking about specific issues, but talking about certain specific items that are set by the law. So, for example, we have a unilateral termination, as we said before, with proper motivation. For example, when the person that is executing the contract dies, or for public order issues, it's advisable to terminate the contract. And for example, Law 80 of 1993 was created at a given time in Colombia where the public order was different than what we have now. So this was a tool. And even for the sake of the individual parties, the places where they can be executed, the people said, well, they have a public order issue. You're going to continue this. Let's complete the contract. Let's close the contract. So this was benefiting the particular parties as well as the private parties. Here we have one that is some kind of reasonable punishment, because when a contractor, the reason because it's hiring with this is an effective execution of the contract. So when the contract is not properly being made and the entity finds there are grounds that are going to set into risk the execution of the contract, they can say we're going to stay the expiration of the contract. And if you come to Colombia, they say caducidad, or expiration, run away, because that's the worst that can happen to a contractor in Colombia. So the expiration don't allow you to hire again with the state for 5 years, and it's a very terrible punishment. If you want to hire here in Colombia, I guess you don't want this to happen to you. And finally, reversion. Reversion, I think, is something that we are going to tackle later on in APPs, and it's an exceptional clause inside exceptional clauses, because it's only working for concessions or APPs, where the contractor has exploited the goods and services of the state or has built them to exploit them. But the people were asking, at the end of the contract, when I operate kept, what is going to happen with the different assets that I created and operated? I have to reverse them to the state, and that is the clause with which me as a contractor of an APP, I have the duty of returning these assets to the state so that they continue with the service rendering that I was providing, being the roads or others. But that is a clause with which the state can say, we finished the contract, give me back the goods that you gave me, then now it's my turn. And we finish exceptional clauses. If you have any question, let's solve it. But this is very important because this is very specific for the contracting regime of Colombia. I guess that you have talked a bit about guarantees, and we have this slide that gives you a glimpse about the most common guarantees, because you're going to find different names and different tenders of the different entities. Sometimes the entity itself is asking a longer terms than the ones that set in the law for the guarantees, but this is basic and this is essential, and we try to gather all the most common guarantees for the contracting processes, and they are divided into the different stages that we have mentioned, or we can mention them again. That is the pre-contractual, post-contractual, and others. So in we have in purple, in blue, light blue, are the ones that were pre-contractual. So for example, the warranty or seriousness of the offer. Because the first one thing that you're going to do is that you're going to be serious in your offer, and they ask you for a warranty because I don't know if this happens in other legal context. Is that I'm going to a tendering process and I say I'm going to offer 1,000 million pesos. So that binds me, that forces me that in the selection process, if I'm the winner, I have to keep that value of the contract. So that warranty covers the risk of the entity that, for example, if I am the winner, I have the possibility of signing a contract and saying, effectively, that is what I offered. Then we have good management and correct investment of the advance. The advance here in Colombia is particularly is a practice that has been left aside, and it's something important to point out for you, that it is the advance in Colombia was considered like a loan that was given by the entity to the particular to start with execution of the contract. And I'm trying to talk with this. I mean, a lawyer would say, how dare you say that? I'm trying to state this in the most didactical manner as possible, because that is the way that it which works. Because I don't have enough resources to start with execution of the contract, even though I talk about my soundness in terms of the economic terms, but the contract is too big. So what happened before is that the state gave me an advance and I execute this, but I also have to be a guarantee of the good management and correct investment of the advance. So what is the proper work? I did it in the proper manner, in the proper time, as it was intended. So as we have an advancement, we have an advance payment. That is not a loan, but they are forwarding the complete payment of the contract to do it. And to cover the risk of this work, I have some warranties. That is the one that we were showing. Later on, we have the warranties that are part of the contractual stage, that are the ones from quality in terms of concession, stability, and quality of the work, that usually are 5 additional years from the termination of the execution of the contract. So if I created a bridge and it took 10 years, for the 10 years I'm covered by this work, and for my additional years. So in the post-contractual stage, we have different warranties for the payment of salaries and workers' compensation, the quality of service, and the compliance of contractual obligations.
I think that with this framework that we've provided here, you can have an idea of the guarantees that may be demanded by a state agency when you're executing a contract. I think there's a question over here. Okay, your comment is very timely. We've come from Willis Tower, Watson, and basically within what we do, guarantee management is very important, both for pre-contractual, contractual, and post-contractual procedures. Just to clarify the issue, they are all guarantees. The difference is that there's just one guarantee here, so that's compliance, and this is all coverage that is requested by the contracting agency, the National Infrastructure Agency for 4G projects. So for each of those stages, they demand a certain amount or series of coverage. And for the companies that come over and are international, there is a process that has been set up in order to manage those guarantees, because it's different to manage guarantees here in Colombia for Colombian companies compared to international companies. Besides, given that guarantees are seen as a whole, when the contracting agency or procurement agency is evaluating the issue in this case, if there is an English company that comes over and joins a Colombian company, as you said earlier, with temporary unions, it's not so much that the Colombian company pays 50% and the English company pays 50%. In this case, the guarantee assessment is done for 100% of the total. So each one will have to provide answers for or cover the guarantee as a whole. Yes, that's a great contribution. So as you were talking about the National Infrastructure Agency and its request for participation or shares, we've got credit groups. It's different. It's a guarantee that's focused on an entirely different issue, but it is something that you should take into account if you're going to participate in infrastructure processes here in Colombia. Just wanted to make a small comment on that commentary. The guarantee doesn't have to be an insurance policy. It can be a bank one, and in this case, it's not for the insurance market. In procurement in Colombia, you need the insurance backup, and within the insurance contract, in effect, as you mentioned, you have one policy with different types of coverage. There are currently significant opportunities in this market because the main insurer when it comes to contractual obligations, public contractual obligations in Colombia, which was the object of state and liquidation intervention, so Condor. So I think that the possibility of going into the public contract guarantee market is a significant and important space, obviously taking all precautions necessary, but I think that it is an infinitely good market opportunity, amongst other reasons, because as you mentioned before, and we've mentioned it before, the most normal practice is to have insurance policies with all the coverage. So the compliance branch would be broken down into all these types of insurance that are pre-contractual, contractual, and post-contractual. And that branch, it has been approved by the Financial Superintendent's Office for very few insurance companies. So that's an interesting business point of exploration. I think I'll leave you with that, but I would like to highlight the importance of the differentiation between consortium and temporary union. The legal advisory required for the contract that will connect you to a company that allows you to participate in the execution of a contract with the state is fundamental here. We have been using it here, and we have encountered gigantic problems with companies that already know about consortiums and temporary unions but still have no clarity about them. So do take that into account, as well as the exceptional clause regime, so that in the future when you read a contract and you can't find the exceptional clauses, it's not so much that they're not there, but they have been agreed because they are in the law. So these are the two most important aspects, as well as the guarantees, and that's what I wanted you to take with you from this part of the presentation. Okay, so going back to the first 3 points, we will now proceed to revise the kind of contracts that are underwritten in the country. As I explained before, those underwritten under Law 80, these types of contracts have been included in the law. So you will find the following 6 types of contracts. So we have concessions, and through these contracts, a state agency gives an individual the operation, readiness, management of a public service or construction or infrastructure, so that this individual can exploit that, manage it, and carry all related activities in exchange for a salary for his services or pay. This is currently a boom due to the PPPs, for the reasons that we will see in Module 6 tomorrow, and you'll be able to identify that this is where most PPPs can take place due to quantities, types of contracts, modes or types of services provided in the concession. So at the moment it's a contract that we need to pay close attention to because of its significant development over the last few years within the country. Then after that we have public works contracts, a contract in which the state entity concedes or derives upon an individual the construction and installment of and any other related activity to public works. It's different to concessions because it's just for the execution of the works. But the importance of the concession, or the difference with public works contracts, is that that includes management. It's not just the construction works. It's construction plus participation and carrying out the activity itself. Then we have consulting contracts. These are underwritten by public agencies, and the object needs to be related to research activities, diagnoses, pre-viability tests as well. And we're going to look at these specifically in the public-private partnership module. And these are generally aimed at carrying out specific programs and activities with technical assistance and technical advisory required by the entities themselves. There's a very similar contract to the consulting contract, and that is the service lending contract. And although these are contracts in which the activities that we intend to hire or procure are for technical advisory, the difference with consulting contracts is that within these, activities need to be intimately related to the activity presented by the state agency. So the objective for which the company was created has to be closely linked to the contract, whereas in consulting it's a little bit more, say, wide. There's another contract that is not very common, but it's also in Law 80, and that is the ones in which commodate contracts in which public agencies give the use of, say, buildings for other people's use or real estate. So in the end, this asset needs to be given back when it's under commodate contract. So it's not part of the equity of the person exercising the contract, but rather what this person or contractor is doing is acting on behalf of the owner, so that the third party can carry out all administration activities or management. With regards to the standards for rural buildings, there's quite a developed standard for this, which isn't the object of this discussion, but it is important. And in the firm and in law, we've had an important or significant experience in this area. As I said, it's a normative field that has been developed and has quite a few particularities. And then we have the public commission, public trust activity. So when a state agency gives an individual who's carrying out trust activities resources so that they can manage them, and they give them these resources. As in the commodate contract, the public commission, public trust contract isn't aiming to give this asset to the individual, but just hands over its administration so that they can administrate or manage this asset or resources, generate a yield, and for that to be given back, or income, and that to be given back to the company lending the contract. So it's really important to take into account that the asset delivered is not part of the equity of the person carrying out the trust. Now we are going to look at the subscription process and modification of the contract. So in the previous module we saw this graph or table in which we generally showed the procedure for procurement processes. So the first stage is the planning stage, in which we simply define the general conditions that will be used to make the process go forward. After the planning stage, when we've completely defined the selection process that will take place, the selection is executed, and in this we are choosing who will be the best third party that guarantees compliance with the company's objective. Once we've selected them, we next go into the adjudication or contract award, to then go into the execution stage. So this graph shows us this particular part from the selection stage to the execution stage. Depending on the kind of contract, the quantity and the conditions in the contract underwritten, we have defined the selection process. It is carried out, and after it's finished, we will define the third party that we will execute the contract with. So then I underwrite it. So once I've defined that proponent A is the most qualified and the one who will guarantee conditions as an entity, and that the contract will be complied with, then we proceed to sign it. But this isn't enough for it to be completely valid or to be absolute and actually generate effects in the real world. So when I signed it, as of that moment, I have to start the execution, because as Gilberto explained in the previous module, there are certain policies in place and a series of activities and clauses. These activities should be performed before signing the contract that guarantee that the contract complies with all the requirements and has been, say, perfected. And in the perfection stage, we look at policies and all the different requirements, and you need to be aware that each procurement process is a whole world developed by the conditions documents or tender documents, which will provide a kind of roadmap or a pathway that we always need to be aware of throughout the execution of the contract, which is understood to be from the moment of execution to liquidation in the contract. So once all these administrative processes have taken place, and these are necessary in order to guarantee the effective start of the contract, we can sign the formal document to start the contract, in which the proponent that has been chosen and the entity agree that all the elements that are needed to execute the contract are ready, and it is possible to start activities. So there's a particular term here. In state contracts we have two terms that need to be taken into account, or terms. So the first is the currency of the contract, and they may both seem similar. You may ask what the difference is. But the difference is that the term for executing the contract is the term that the contractor has to perform the activities that have been handed to them, and this is different. This is the initial record. For example, if I've been hired to build a road from point A to B and I was given 2 years, the term of execution will be 2 years in the contract, because that's the term I have to build this road from point A to point B, whilst my term of validity or currency will be the 2 years that I have to build it, but also an additional 2 years for the settlement. In other words, the validity term is greater than the execution term, because I have to meet my responsibilities as contractor, but additionally I have to carry out all the activities that are linked to closing that contract, because given that in order to start the contract, it's not just a case where you need to sign, it's also the same when you sign the closing record. You don't just sign the closing record to stop the contract, or you have to settle it as well. But then there's a very specific issue here as well. During the execution term for the contract, a number of legal figures for modification are presented, and this is different to unilateral modifications that we worked on with Gilberto. These modifications are consensual modifications. They've been signed, they've been agreed between the different parties, and there are 3 types of modifications. It's very important for you to take them into account, because they can only be carried out throughout the term of execution of the contract, and it is as follows. First is modifying the contractual obligations. The modification of contractual obligations is any change that is carried out on the initial document for the contract that does not affect the object. So the only clause and the only aspect that I, as an entity or contractor and contracting body, cannot modify. For example, if I was hired or contracted to build the road from point A to B, throughout the execution of the contract, they can't say I'm not going to build a road, but I'm going to build a building, because they are 2 different things. But they can say we're going to build the road from point A to point B, but we're not going to use a one-way, road. We're going to have a 2-way lane. So they just change particular conditions without actually changing the object of the contract. And you can change other kinds of activities or situations or clauses as long as the object of the contract is not changed. This is a very important aspect that should be taken into account, not just for these types of modifications, but for any other kind of contract modifications. And you should take into account the request and the justification on the part of the contract supervisor. We have this legal figure here. It's a third party who performs surveillance to ensure that they are meeting the terms agreed in the contract and everything else agreed in the contract. So an external body guarantees that, they have no interest in the matter or stakes in the matter. They are able to comply with this, and they guarantee for the contracting body that the person who was hired to do this is complying with that which we stated that they should be hired for, and the way it was contracted in the term that it was contracted for. So that would be a third party, as I understand it, because public contracts are done within the entity, right? We have two figures, so we have the supervisor and the auditor. So technically, the supervision is carried out by an internal worker, but audits are done externally with third party. Both figures are possible in Colombia. So we have supervision. This is the general concept for including audits and supervisors. This can be done internally, but it can also be done externally. So the entity, not just at this selection point or stage can they decide that they will hire services, but rather due to convenience or importance or any other reason, complexity as well, the supervision or the auditing of the contract will not be done by a worker in the company, but a third party. So it's not just about defining a contracting process or procurement process for the subject, but also they write another contract for supervising. That's why in this kind of consulting contract type of contract, we talk about supervision. So it's a contract. Supervision is a technical contract in which a third party guarantees externally that there is compliance. So I think the clarity is timely here. In Colombia, when we technically talk about supervision, we're talking about internal activities, but we could also talk about supervision or auditing, which is external. When we talk about supervision, both of them come into play here, both the auditing and supervision. Okay, so once the need has been requested and justified on the part of the supervisor, then we can move on to formalizing or legalizing the modification. In Colombia, when it comes to state contracts, everything needs to be written, and so that's something you should all take into account. We need verbal instructions, or those provided by the supervisor or entity or the legal representative of the entity. If they are not written down and signed by the counterparts, then they have no validity. They are not ruling contracts or modifications. So once they have been agreed, these modifications, the request of the supervisor needs to be captured in the document, and it needs to be signed by both parties. And as I mentioned initially, that could be carried out at any point in time throughout the contract, and even just before finishing the term of execution. We have another way of modifying the contract, and that is through extensions. So we have additions and extensions. These are two terms that are normally confused, and it's really important for you to take that into account. The extension only includes time. So when I'm extending a contract, I'm not giving the contractor more resources to execute an activity. When I'm extending the contract, it's just to do with time. So if we go back to the same road example, they gave you 2 years to build from point A to point B, but for one reason or another, it no longer takes 2 years. It will take 2 years and 3 months, so I can extend the contract by 3 months. It won't require any additional resources. It's just an extension of the contract. Whilst an addition, on the other hand, is a figure that we use to increase the resources that were allocated to this contract. So, for example, if I had 100 pesos to execute an activity, but I've realized that for one reason or another it will not cost 100 pesos, it will be 110 pesos, then I need to add 10 pesos to my contract and create this addition. And in additions, there is an issue that makes it different to other kinds of modification, because both in the modification of the contract and the extensions in time, you have no kinds of limitations. If you've underwritten a contract for 6 months initially and you need to add 8 months, then you can do that and there are no problems there. On the other hand, whilst we're talking about resources, they do have a limiting factor, and that is that they can be no more than 50% of the initially agreed value. For example, if that's 100 pesos, then I can't add more than 50 pesos to that, 50%. Finally, the electoral guarantee law is quite specific in Colombia, derived from Law 996 of 2005. It's a situation through which, within contracting process, we try to ensure that we do not favor, or rather in election processes for public servants, so governors, mayors, presidents, there should be no we should not favor any of them or buy votes through direct contracting or direct procurement. We're not suspending contracting or procurement services, but rather it's what we're doing is temporarily suspending contracts that are adjudicated directly. So public tenders, awards, everything else is executed in the same way as provided by law, but 4 months before defining the person who will be elected, direct procurement processes are suspended. There are 4 cases deriving from the electoral guarantees law. That means that they can be procured directly when there's fortuitous cases or public credits, or for example when it's for an emergency, health or natural disasters, and also when it's related to defense of the state and weaponry. Finally, with regards to your operations as companies and how companies can operate, not just, as Gilberto said, the legal persons that can participate in procurement processes, but you as foreigners or foreign companies, how can you participate? So that's why we have national companies that are made up or created in Colombia under Colombian law, and that could be done with foreign partners or foreign investment, but you reside in Colombia and you conform to laws in Colombia. And there are also foreign companies that have a certain degree of intervention in the Colombian market, so they have brands here in Colombia, or also foreign investment in Colombia. Article 469 of Colombian laws specify that foreign companies mainly reside abroad and they have been constituted through foreign laws. So that's what Colombian standards and law states is a foreign company. It doesn't mean that they can't participate in Colombia. Of course they can. In order to participate in Colombia, they should have 2 requirements. The first is a protocol document, so a foreigner can come to Colombia and participate in that as long as they have a protocol for their existence and their manifesto of intention, so that they can participate in Colombia by creating it or signing a document at the notary registrar. Given the market in Colombia, some markets are, say, controlled by the state. So that means that you don't just need the protocol document, but you also need banking. So if it's related to the financial sector, then that needs to be authorized by a special institution here in Colombia. In this particular case, you need authorization from the Financial Superintendent's Office. That is the institution. And when we talk about permanent activities, we were talking about the intention to stay, to remain in Colombia. The standard considers permanent activities to be any that include contract. So if you write a contract or sign a contract with a state agency, then there is a certain intention to remain. But once that's been underwritten, you need to guarantee that the company or your stay as a company in Colombia or brand in Colombia will last throughout the period in which the contract is valid, plus 1 year for settlements. So these are 4 tips that you need to take into account for cases in which you, as a foreign company, will participate in the country. So you need to have been constituted through a decision that has been adopted by the headquarters or those governing. You need to put the name down, the business, the term that you will be here, the amount of contributions from the foreign company, and clearly you will operate not so much as an autonomous entity, but rather in representation of the constituents, and they are abroad. Finally, just to end, we want to look at restrictions that may catch your eye. And as a foreign agency or entity, how might you be restricted when it comes to participating in procurement processes in Colombia as foreigners? So here it's really important for you to take into account that in our political constitution in Colombia, we have defined economic freedom. In Colombia, all actors in the economy work and participate in the same way. So the important thing here is that when a foreigner participates in the country, they should take into account that they will have equal conditions to other private individuals, whether they are foreign nationals or national citizens, allowed for intervention. So what you'll find, and this is very common in procurement processes, as I said before, tender documents are the framework and the guideline that we will use to perform the execution and the settlement of the contract. So often you'll find on these tender documents that there will be kind of a way of fostering Colombian industry, and as foreigners you will not be scores will not be taken away from you for being foreigners, but you may have additional scores if you contribute to the industry here, but it's not so much that just because you are foreigners you will have greater participation or lower participation in the Colombian market. That's not the case. That's my presentation. I don't know if you have any questions or queries. We are open to listening to them. We'd like to emphasize the importance of being well advised throughout each period. As I explained, our normative framework truly sticks to the law and standards. So it's really important that with regards to legal techniques, you are completely accompanied with people who understand the issue. Thank you. I'd like to go back to temporary unions and consortiums. With regards to tax issues, what is the difference when I have a temporary union with another company? In fiscal terms, there is no difference between them. One of the aspects that Gilberto showed us in his presentation was that given that you don't create a new company as such, it is not a new subject of law. So there's no new subject in terms of taxes. So your tax obligations as consortiums and temporary unions or depend on the contract. It's not so much that consortium A or B will have to additionally pay taxes additionally to what the partners are paying. Understand that there is a difference because the temporary union and the consortium in both cases are obliged to generate a tax record number. The difference is that those in the plural structure should send invoices independently, or should they send them through the structure? I don't know if there's a difference there. I think it's a tax management issue, but it's not an actual difference with regards to the tax load that you will have as a legal figure. So if I'm an anonymous society or company and I'm going to participate in a consortium, I take all my tax obligations with me as a company, but not as part of the temporary union. And then, according to the obligations in the contract, I have a certain fiscal charge that I should continue to pay, but it doesn't belong to the temporary union as such. I don't know if that's clear. So the consortium contract or the temporary union contract per se doesn't have an additional tax to that which the consortium or those in the or those members already have. They do not have additional taxes to pay. The comment made in the presentation about the
It caught my attention the idea of a permanent work of the foreign companies, because in some selection processes, in some tendering processes with the government, mostly when we talk about consulting, when we are supposed to do this in a rather short amount of time, these processes can take from 6 to 12 months. There are some companies that have requested not to consider permanent vacation in the country when the contract is executed as such, because the consulting contract as such, it doesn't even require to be in the country itself, because there are no activities that are being held locally. And also the will of the company to be permanently located in the country, because it has a limited amount of time. So there is a debate whether, in terms of possibilities of merits, the person can have the permanence, can have the stay in the country, and that was something that was not clear, because there are arguments on side and side to justify both criterion. I don't know if you have a specific stance on the matter. Well, currently it's a topic that is being debated, and it's quite up to date in the jurisdiction and in the entities as well. But as you said, the people have stated that when we were talking about with which were the situations that the norm understands as permanence, we don't have find elements like consultancy that can be done everywhere without a specific presence, a timely specific work. And this is quite relative, and we find that there's something very relative, because even the jurisdiction itself hasn't been able to set a specific position. So we find decisions that go in both sides, and we consider that every specific case has to be considered with the particularities it has, because the same conditions will set the specific conditions for the tender, for the provider that is going to be there. So we have to see the specific case to define whether it applies to one case or another. I totally concur with you with the intervention that Carlos did. Basically speaking, the criteria to find this occasion is given by the contract and the terms that are going to last in the execution. So as this works, this is not going on a specific area to talk about this vacation of permanence and how has to be specified in every case. If we are going to present a proposal for a consultancy, even if you are providing this overseas, it is important to guarantee to the public entity that, as it is not a form requisite, I'm going to have a physical presence of a person that is going to be my spokesperson, is going to be my representative on earth for the sake of the contractual execution. Because on the other hand, considering that there is not a unified stance as a wrap-up body, you may lose points in a necessary manner. So our suggestion would be, let's try to guarantee a physical presence, a minimum at least, in the time that the contract deems necessary according to the scope and the length. Because and I'm talking about the legal conditions of the requirements in terms of a local entity. Yeah, but it's something that can close your market if the one that is creating this has the interpretation that you need a physical uninterrupted presence for a vocation of permanence. The requirements of having a physical person on having a legal person already established in the country. Yeah, indeed. But the status of permanence, that's why we have the possibility of hiring with entities located overseas. Thing is that the availability during the execution of the contract according to the scope with the minimum requirements. But in the case that you're pointing out, the important interpretation is the one that Lorena mentioned first, and is to keep during the tenure of the contract, as Carlos mentioned properly, uh, to keep the proper society. And it's quite odd and interesting to me that one entity allowed to do something different, because if there is non-compliance, what can I do then? And the limit, the edge of this, and where we have conflicts, is in liquidation, in execution as well. But for example, when I sit down with the entity to see what I was doing, how much are they owing me, etc., and vice versa, if you fulfill your requirements or no, that is where we specifically have the conflicts, because we are talking about money, because the society has to be there not only for the execution of the contract, because most of the times we want to make it last for 2.5 more years. That is the time that I have as a particular as an entity to liquidate the contract. So I would set on the understanding that as a legal entity, stay here in Colombia, the execution of the contract, and 2.5 more years. I think that it is important to to take advantage of this Q&A session, talking about something that was mentioned before about the hiring mechanisms, talking about the different elements that are handled. Who had a question concerning this issue? Who had a question about the stock exchange? I understand that the question is, what is the higher mechanism that can be used through the stock exchange of Colombia, and what is the kind of regime that you can apply to it? So there are two issues that have to be considered. First, the stock exchange of Colombia is based on the agricultural market. It was considered agricultural national stock exchange, and the idea was a proposal, a common proposal of two ends of the market to talk about agricultural issues. On 2002, we have the stock exchange of Colombia, and the contracting regime allows this to be traded through this market, goods with technical qualities that are homogeneous. For example, the chairs that are going to be purchased for the public schools by the Ministry of Education, or the school food. And this is a forum that is very transparent and is used quite fostered, despite the fact that, considering that with the launch of Colombia Compra Eficiente, we know that there are two forums with the elite, that there are two forums that compete with each other. But you can go to the stock exchange of Colombia, and this is providing physical resources, physical assets. And I'm not only talking about food, that is what usually was traded in this stock exchange, but we have, for example, furniture, and they come with a specific magnitude, with a specific amount of time. And for example, what we are looking for is to optimize the price in a scale economics, and that's why the regime goes down. The conditions are quite properly set. We have those terms set in the stock exchange of Colombia, and we have an experience that deals on the matter, because we have been working with this contractual regime. I don't know if there's another question on the matter. Are there warranties, maybe? Is there a question about warranties? I think that we already solved that. We sorted that one out. So we're not going to tell you too much. And now we invite you to take a break from this session.